climate change and international law. This morning we will hear oral statements from the Philippines and Sierra Leone. I now give the floor to the representative of the Philippines, Mr. Soreta, to make his statement. You have the floor, sir.
Mr. President, distinguished members of the Tribunal, good morning. It is an honor and an imperative for the Republic of the Philippines to appear before the Tribunal and be part of these proceedings. Proceedings that could prove to be the crucial turning point in collective efforts to turn the tide on climate change.
I am Carlos D. Soreta, Philippine Permanent Representative to the United Nations in Geneva and representative for these proceedings.
I am joined by my co-representatives, Ambassador Maria Angelo Ponce, Assistant Secretary for Maritime and Ocean Affairs of the Department of Foreign Affairs, and Assistant Solicitor General Gilbert U. Medrano of the Office of the Solicitor General. We will speak for approximately 60 minutes. I will speak first by way of introduction, followed by Assistant Solicitor General Medrano, who will touch on relevant Philippine laws and discuss jurisdiction, admissibility, and applicable law. Ambassador Ponce will then expound on the Philippines' response to question A, after which I will address question B and conclude our presentation. Mr. President, from the time that COSIS filed the request for an advisory opinion last December to today's hearing, 9 devastating typhoons have battered my country. Lives have been lost, people hurt and displaced, cities and towns flooded, and large areas of farmlands inundated. The trajectory and magnitude of our typhoons have become even more erratic and even less predictable. Between 2011 and 2021, typhoons caused 12,000 deaths, countless injuries, and $12 billion worth of loss to my country. The worst of these was Super Typhoon Haiyan in 2013, which resulted in over 6,000 fatalities and remains among the top 10 deadliest in all of history. When not battered by typhoons, we are hit by periods of drought caused by El Niño, a weather phenomenon which is exacerbated by climate change. Farms dry up, coastal fishing areas end up empty, and people go hungry. The Philippines ranks first among countries most at risk to disasters and extreme natural events such as tsunamis, floods, and drought. Such vulnerability is evident in our coastal and marine ecosystems, which are now deteriorating at alarming rates. Studies and reports reveal coastal erosion, bleaching of coral reefs, loss of seagrass, and conversion of mangrove areas, which in turn affect marine resources and the livelihood of our coastal communities. As an archipelagic state comprised mostly of small islands and one of the most vulnerable to and most affected by climate change, the Philippines stands in solidarity with COSIS and all the small island states that comprise it and outside of its membership, and support their initiative to request the Tribunal's advisory opinion. Fundamental to our position is that while UNCLOS was not designed as a mechanism for regulating climate change, its mandate is broad enough to consider the connection between climate and the oceans. This 40-year-old framework agreement must be interpreted in light of changing global circumstances and changing laws. It is, among others, a strong, innovative, and comprehensive global environmental treaty governing over 2/3 of the planet. It must be interpreted and applied with subsequent developments in international and policy in mind. At this point, Mr. President, and with the Tribunal's permission, may I ask my co-representative, Assistant Solicitor General Gilbert Medrano, to continue by placing in context how Philippine law has been protecting the environment and contributing to the fight against climate change, as well as discuss the issues of jurisdiction, admissibility, and applicable law.
Thank you, Mr. Soreta. I now give the floor to Mr. Medrano to make his statement. You have the floor, sir.
Mr. President, the distinguished members of the Tribunal, good morning. When President Ferdinand R. Marcos Jr. addressed the United Nations General Assembly last year, he stressed that climate change is the greatest threat affecting our nations and peoples. Our participation today emphasizes how the Philippines considers these advisory proceedings and the central role the tribunal plays in addressing this existential threat in the Anthropocene epoch. Before I proceed, allow me first to state the context in which the Philippines has been protecting the environment through our national laws, which shape and inform our position in these advisory proceedings. The protection and advancement of the right to a balanced and healthful ecology is a fundamental right enshrined in Section 16, Article 2 of our Constitution. The highest court of our land, our Supreme Court, interpreted this provision in the landmark case of Oposa versus Factoran, where it held that the right to a balanced and healthful ecology need not be written in our Constitution, for it is assumed, like other civil and political rights guaranteed in the Bill of Rights, to exist from the inception of humankind, and it is an issue of transcendental importance. Such right carries with it the correlative duty to refrain from impairing the environment. Further, we have in our jurisdiction the concept of intergenerational responsibility, which affords legal standing to sue for the enforcement of environmental rights in representation of future generations. As a party to the United Nations Framework Convention on Climate Change, or the UNFCCC, the Philippines adheres to the Convention's ultimate objective, which is the stabilization of greenhouse gas concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference with the climate system to ensure food security and sustainable development. This objective is enshrined in our Climate Change Act. We have several other domestic laws on marine environmental protection that address marine pollution and toxic substances and hazardous waste. Establish an environmental policy and institutionalize a system of environmental impact assessment, or EIA, for marine protected areas. Non-compliance with the requirement of EIA has been ruled by our Supreme Court as a serious statutory violation. The Philippines has also led in climate legislation with laws to reduce black carbon, address wastewater pollution, promote clean, sustainable energy, strengthen climate governance, finance local adaptation, transition to a green economy, and more recently, pursue effective and judicious use of energy. Beyond the statutes, the Philippine Supreme Court likewise promulgated rules concerning environmental cases, that is, the rules of procedure in environmental cases, which aim inter alia to protect and advance the constitutional right of the people to a balanced and healthful ecology through a special remedy called writ of kalikasan. All the foregoing demonstrate the Philippines' serious efforts and particular attention to marine environmental protection as an archipelagic and a developing state. These are our contributions to making marine environmental protection a global norm. Mr. President, I will now briefly tackle the issue of jurisdiction and admissibility. The Tribunal's advisory jurisdiction, outside of the competence of the Seabed Disputes Chamber, is settled in the Sub-Regional Fisheries Commission advisory opinion. Here, the Tribunal pronounced that its advisory jurisdiction derived from Article 21 of its statute, or Annex 6 of UNCLOS, read together with Article 138 of its rules. This is now set in stone, and for the Philippines, there is no reason to depart from the said ruling. Having satisfied of its competence in the said case, the Tribunal further indicated the prerequisites for its advisory jurisdiction, based on Article 138 of its rules, namely, first, an international agreement related to the purposes of the Convention that specifically provides for the submission to the Tribunal of a request for an advisory opinion. Second, the request must be transmitted to the Tribunal by a body authorized by or in accordance with the agreement mentioned above. And third, such an opinion may be given an illegal question. It is the Philippines' position that COSI's request satisfies the prerequisites for the tribunal to assume advisory jurisdiction. The agreement for the establishment of the Commission of Small Island States on Climate Change and International Law is an international agreement between and among small island states whose mandate is related to the purposes of UNCLOS, in particular, the protection and preservation of the marine environment. Moreover, Article 2, Paragraph 2 of the said agreement empowers COSIS to request ITLOS advisory opinions on any legal question within the scope of UNCLOS. Equally important, the questions posed by COSIS are legal in nature, as they require the tribunal to interpret specific provisions of UNCLOS without implicating any dispute between or among states parties. On the matter of admissibility, it would suffice for our presentation to state the jurisprudence of the International Court of Justice, ICJ, in the legality of the threat or use of nuclear weapons, whereby the court said, "It is well settled that a request for an advisory opinion should not, in principle, be refused except for compelling reasons." The Philippines does not see any compelling reason for the tribunal to refuse its advisory jurisdiction. Rather, what exists are compelling reasons for the tribunal to exercise its jurisdiction and carry on with its advisory competence. Mr. President, I will now lay down the foundation of our analysis by articulating the applicable laws that are pertinent to answering the questions before the tribunal. Article 23 of the Tribunal's statute states that the tribunal shall decide all disputes and applications in accordance with Article 293 of UNCLOS, with the understanding that the word applications covers requests for an advisory opinion. Article 293, paragraph 1 states that a court or tribunal having jurisdiction under this section shall apply this convention and other rules of international law not incompatible with this convention. By the strength of these two provisions alone, it is clear that UNCLOS allows cross-reference with other rules or sources of international law, as long as they are compatible with it. Part 12 of UNCLOS on the protection and preservation of the marine environment, in particular, Section 11, Article 237 states, "The provisions of this part are without prejudice to the specific obligations assumed by the states under special conventions and agreements relating to the protection and preservation of the marine environment that were previously concluded or which may be concluded in furtherance of the general principles set forth by UNCLOS. Likewise, specific obligations assumed by states under special conventions with respect to the protection and preservation of the marine environment should be carried out in a manner consistent with the general principles and objectives of the convention." In other words, UNCLOS explicitly recognizes and advances its synergy with other related international instruments. We are likewise reminded of the rules and treaty interpretation under Article 31, Paragraph 3, Subparagraph C of the Vienna Convention on the Law of Treaties, VCLT, which takes into account, together with the context, any relevant rules of international law applicable in the relations between the parties. This interpretative approach was employed in the South China Sea arbitration, particularly in the award on jurisdiction and admissibility, whereby the arbitral tribunal considered relevant provisions of the Convention on Biological Diversity, CBD, for the purposes of interpreting the content and standard of Articles 192 and 194 of UNCLOS, relying on the strength of Article 293, Paragraph 1 of UNCLOS and Article 31, Paragraph 3 of the VCLT. Likewise, in the award on merits, the arbitral tribunal considered the Convention on International Trade in Endangered Species of Wild Fauna and Flora, CITES, as forming part of the general corpus of international law that informs the content of Articles 192 and 194, Paragraph 5 of UNCLOS. In the same vein, in interpreting the specific provisions of UNCLOS that are implicated in these advisory proceedings, the Philippines will make reference to related conventions and rules of international law to arrive at a holistic position that extols the synergy which the UNCLOS invites with the relevant corpus of international law. At this point, Mr. President, with the Tribunal's permission, allow me to turn over the floor to my co-representative, Ambassador Maria Angela A. Ponce, to continue the Philippines' oral statement. Thank you very much.
Thank you, Mr. Medrano. I now give the floor to Ms. Ponce to make her statement. You have the floor, Madam.
Mr. President, distinguished members of the Tribunal, good morning. I will discuss the Philippines' position on the first question, that is, what are the specific obligations of states parties to the UNCLOS, including under Part 12, to prevent, reduce, and control pollution of the marine environment in relation to the deleterious effects that result or are likely to result from climate change, including through ocean warming and sea level rise and ocean acidification, which are caused by anthropogenic greenhouse gas emissions into the atmosphere. Article 1, paragraph 4, distills the elements of what constitutes pollution of the marine environment. First is its nature. It is a substance or energy. Second is its source. It is anthropogenic or introduced by man, directly or indirectly, into the marine environment. Third is the result. It results or is likely to result in deleterious effects, of which an indicative list is provided, such as harm to living resources and marine life, hazards to human health, hindrance to marine activities, including fishing and legitimate uses of the sea, impairment of quality for use of seawater, and reduction of amenities. The Philippines submits that greenhouse gas emissions fulfill these elements and therefore qualify as pollution of the marine environment. Mr. President, the science behind climate change and the effects of greenhouse gas emissions on the marine environment is unassailable. The sixth assessment report of the Intergovernmental Panel on Climate Change, or AR6, confirms that human activities, principally through emissions of greenhouse gases, have unequivocally caused global warming. The IPCC further stresses it is unequivocal that human influence has warmed the atmosphere, ocean, and land. Widespread and rapid changes in the atmosphere, ocean, cryosphere, and biosphere have occurred. The IPCC's Working Group's 2 contribution to the AR6, Chapter 3 on Oceans and Coastal Ecosystems and Their Services, provides scientific evidence that climate change is affecting marine ecosystems through rising sea temperatures, ocean acidification, and sea level rise. Greenhouse gases such as carbon dioxide are both substance and energy that heat up the oceans. It is well established that oceans are sinks and reservoirs of greenhouse gases. They have taken up to 20 to 30% of total anthropogenic carbon dioxide emissions since the 1980s. The global ocean is centrally involved in sequestering anthropogenic atmospheric carbon dioxide and recycling many elements, and it regulates the global climate system. The impacts of greenhouse gases on oceans include ocean warming, ocean acidification, and sea level rise, which in turn cause harmful effects to marine life, human health, and marine activities such as fishing, among others. Ocean warming causes migration of certain fish species and kills corals, adversely affecting other marine resources. According to the 2016 and 2017 Philippine Climate Change Assessment reports, the highest positive anomaly occurred in 1998 during one of the most significant El Niño events in the equatorial Pacific, which caused widespread drought in the Philippines. Previously, in 1998 to 1999, the first massive coral bleaching was observed in the country. It was noted that coral bleaching was correlated with abnormally high sea surface temperature. Currently, moderate El Niño is present in the tropical Pacific, including in the Philippines, and is expected to strengthen in the coming months until the first quarter of 2024. The Philippines agriculture sector will be most likely affected by the limited water supply, decreased agricultural productivity, fish kills, and coral bleaching. Ocean acidification, as a result of higher carbon dioxide in the atmosphere, disrupts carbon chemistry, making it more difficult for marine organisms to build shells and structures. This could slow down their overall growth and reproduction and thus reproduce abundance. It could also suppress reef formation and production. Sea level rise, on the other hand, could alter river flows and in turn change the distribution of salinity and freshwater in mangrove areas, eventually reducing their diversity and zonation. As sea level rise, mangroves migrate inland to agriculture areas. In addition, the number and severity of typhoons will likely cause more structural damage to reef and seagrass systems due to increased tidal activities. Intense rainfall likewise causes inundation of nesting grounds of various marine species and could potentially increase fungal pathogen loads that leads to their mortality. Mr. President, I will now discuss the specific provisions under Part 12 that are relevant to answering the first question. And these are namely under Section 1, General Provisions, Article 194 on measures to prevent, reduce, and control pollution of the marine environment, Article 195 on the duty not to transfer damage or hazards or transform one type of pollution into another, and Article 196 on the use of technologies or introduction of alien or new species. Under Section 5, international rules and national legislation to prevent, reduce, and control pollution of the marine environment, we have Article 207 on pollution from land-based sources and Article 212 on pollution from or through the atmosphere. And under Section 6 enforcement, we have Article 213 on enforcement with respect to pollution from land-based sources and Article 222 on enforcement with respect to pollution from or through the atmosphere. This list is by no means exhaustive of all applicable provisions under Part 12, but for my delegation, these are the palpably relevant articles that relate to the first question. In interpreting these provisions and the other provisions of UNCLOS that bear significance on the questions before the Tribunal, the South China Sea arbitration, which has been cited extensively by many states participating in these proceedings, provides a most authoritative determination on the obligation to protect and preserve the marine environment. It pronounced legal doctrines that could help determine the outcome of these proceedings. The South China Sea arbitration is legally binding international law, with its proceedings faithfully carried out in accordance with UNCLOS. It has been cited by this tribunal itself in its Mauritius versus Maldives decision. Its validity cannot be assailed. Article 192 provides the general obligation of states to protect and preserve the marine environment. As submitted by the Philippines in the South China Sea arbitration, we consider this to form part of customary international law, which covers areas within national jurisdiction, as well as areas beyond national jurisdiction. This requires states to take active measures to prevent harm, to conserve marine living resources, and to preserve the ecological balance of the oceans as a whole. Article 194, paragraph 1, establishes the obligation to take, individually or jointly as appropriate, all measures that are necessary to prevent, reduce, and control pollution of the marine environment. This pertains to two specific obligations, namely, the obligation not to cause damage to the environment of other states and of areas beyond the limits of national jurisdiction, or the no-harm rule, and the obligation of due diligence. I will elaborate on this when discussing the subsequent provisions under Part 12. This obligation applies regardless of where the greenhouse gas emissions, which as posited earlier qualify as pollution of the marine environment, originate. It also does not matter whether this marine pollution occurs within or outside a state's national jurisdiction. This point was clarified in the South China Sea arbitration, where the arbitral tribunal said that the environmental obligations in Part 12 apply to states irrespective of where the alleged harmful activities took place, and that the obligations in Part 12 apply to all states with respect to the marine environment in all maritime areas, both inside the national jurisdiction of states and beyond it. We should relate this to Article 194, Paragraph 3, which emphasizes that all necessary measures taken shall deal with all sources of pollution of the marine environment. This measure shall include, inter alia, those designed to minimize to the fullest possible extent the release of greenhouse gases from land-based sources and from or through the atmosphere, as stated in subparagraph A. This likewise applies to pollution from vessels and installations and devices mentioned in subparagraphs B, C, and D, insofar as they contribute to greenhouse gas emissions. Greenhouse gases are emitted from land, air, and sea, covering all areas where anthropogenic activities take place. And Article 194, Paragraph 3 deals with all these sources of pollution. In fulfilling their obligations under Article 194, Paragraph 1, it is clear that states shall use the best practicable means at their disposal and in accordance with their capabilities. In the context of climate change, this pertains to the common but differentiated responsibilities and respective capabilities in Article 3, Paragraph 1 of the UNFCCC, which is now a widely recognized principle of international law. We will discuss this further under question B. In this regard, Article 194, Paragraph 1 mandates states parties to endeavor to harmonize their policies. Article 194, Paragraph 2 points to a more specific obligation that states shall take all measures necessary to ensure that activities under their jurisdiction or control are so conducted as not to cause damage or pollution to other states and their environment, and that pollution arising from incidents or activities under their jurisdiction or control does not spread beyond the areas where they exercise sovereign rights in accordance with UNCLOS. This is a clear reference to and a codification of the no-harm rule, that is, the principle of sic utere tuo ut alienum non laedas, which is customary international law. First stated as Principle 21 of the Stockholm Declaration, that states have the responsibility to ensure that activities within their jurisdiction or control do not cause damage to the environment of other states or of areas beyond the limits of national jurisdiction. It was reiterated in subsequent important environmental pacts and instruments, such as Principle 2 of the Rio Declaration and Article 3 of the Convention on Biological Diversity. The Trail, Smelter, and the Corfu Channel cases were the early cases that enunciated the no-harm rule, but it was the ICJ advisory opinion and legality of the threat of the use of nuclear weapons which established that the existence of the general obligation of states to ensure that activities within their jurisdiction and control respect the environment of other states or of areas beyond national control is now part of the corpus of international law relating to the environment. The pronouncement has been reaffirmed in subsequent ICJ cases, such as the Gabchikovo-Nagimaros project and the pulp mills on the river Uruguay. The Philippines is of the position that the no-harm rule, as a customary norm, is not limited to causing harm in the territory of another state, but includes damage caused in areas beyond national jurisdiction. This is solidified by the adoption of the agreement under the United Nations Convention of the Law of the Sea on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction, or the BBNJ agreement, which among others provides that when a party with jurisdiction or control over a planned activity that is to be conducted in marine areas within national jurisdiction determines that the activity may cause substantial pollution of or significant and harmful changes to the marine environment in areas beyond national jurisdiction, that party shall ensure that an environmental impact assessment of such activity is conducted. The Philippines will join the international community in signing this landmark treaty tomorrow in New York. As a customary norm that informs the content of Article 194 of UNCLOS, the no-harm rule creates an obligation on all states parties to ensure that their activities do not aggravate the current situation by further contributing to the warming of the planet and of the oceans. This thus requires states to limit their greenhouse gas emissions consistent with their obligations under the UNFCCC and the Paris Agreement. Related to Article 194, Paragraph 2, are Articles 195 and 196, such that in taking all these measures necessary to prevent, reduce, and control pollution of the marine environment, including those resulting from the use of technologies under their jurisdiction or control, states shall act so as not to transfer directly or indirectly damage or hazards from one area to another or transform one type of pollution into another. Articles 207 and 212 mandate that states shall adopt laws and regulations to prevent, reduce, and control pollution of the marine environment from land-based sources and from or through the atmosphere. In addition to adopting such laws and regulations, Articles 213 and 222 require states to enforce the laws and regulations they have so adopted. These provisions, taken together, serve to operationalize the obligation of due diligence. That is, the obligation for states to ensure that their laws and regulations are enforced effectively within their jurisdiction. Articles 207 and 212 also mandate that states shall take other measures as may be necessary to prevent, reduce, and control pollution of the marine environment, while Articles 213 and 222, respectively, further require that states shall adopt laws and regulations and take other measures necessary to implement applicable international rules and standards established through competent international organizations or diplomatic conference to prevent, reduce, and control pollution of the marine environment from land-based sources and from or through the atmosphere. With respect to the pollution from vessels and installations and devices in subparagraphs B, C, and D of Article 194, Paragraph 3, the same obligation of due diligence could be derived from the provisions relating to enforcement by the flag, port, and coastal states in Articles 217, 218, and 222, and 220, respectively. Mr. President, the due diligence obligation is related to the no-harm rule. The no-harm rule is the obligation not to harm or pollute the marine environment, while due diligence is the obligation to undertake means to ensure that such obligation not to harm is carried out. From the South China Sea arbitration, we can deduce that the obligation of due diligence is twofold. First is adopting appropriate rules and measures to prohibit a harmful practice, and second is ensuring enforcement or compliance with said rules and measures with the qualification that the obligation to ensure is an obligation of conduct and not of result. As the ICJ pronounced in pulp mills on the River Uruguay, and as reiterated by the Tribunal in its advisory opinion in the Sub-Regional Fisheries Commission, the obligation of due diligence entails not only the adoption of appropriate rules and measures, but also a certain level of vigilance in their enforcement and the exercise of administrative control applicable to all public and private entities under its jurisdiction. But what exactly is the content of these rules and regulations and all other necessary measures that states shall enact and enforce within their jurisdictions to prevent, reduce, and control greenhouse gas emissions? Employing the interpretative approach we have laid down earlier, and in the context of climate change and its deleterious effects on the marine environment, the provisions I just discussed can only have substantive meaning by making reference to the UNFCCC and the Paris Agreement. In particular, these rules and regulations and other measures should, inter alia, aim towards the realization of Article 2 of the UNFCCC for the stabilization of greenhouse gas concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference with the climate system, and as fleshed out in Article 1, Paragraph A of the Paris Agreement, by holding the increase in the global average temperature to well below 2 degrees centigrade above pre-industrial levels and pursuing efforts to limit the temperature increase to 1.5 degrees centigrade above pre-industrial levels. For this purpose, the Philippines notes the universal or near universal adoption of these two agreements, which now make them part of the general corpus of international law, similar to the characterization of the CITES Convention made by the Arbitral Tribunal in the South China Sea arbitration. Mr. President, Article 194, Paragraph 5 states that measures taken shall include those necessary to protect and preserve rare or fragile ecosystems, as well as the habitat of depleted, threatened, and endangered species and other forms of marine life. Indeed, as I have discussed, ocean warming, sea level rise, and ocean acidification have adversely affected critical marine ecosystems and habitats. This article is peculiar because although it falls under the chapeau of measures to prevent, reduce, and control pollution of the marine environment, it pertains more to the protection and preservation of the marine environment. The provision highlights that inevitable nexus between pollution management and the protection and preservation of ecosystems. As explained in the Chagos Marine Protected Area Arbitration, Article 194 is not limited to measures aimed strictly at controlling pollution and extends to measures focused primarily on conservation and preservation of ecosystems. The control of pollution forms an important part, but by no means the only aspect of environmental protection. Question B of the request for advisory opinion pertains to that wider net of environmental protection, which will be discussed by my co-representative, Ambassador Sureta. May I ask, Mr. President, that you give the floor to Ambassador Sureta. Thank you.
Thank you, Ms. Ponte. I now give the floor to Mr. Sureta to continue his statement. You have the floor, sir.
Thank you, Mr. President. The second question relates to a key pillar of UNCLOS, the protection and preservation of the marine environment, as enshrined in its preamble and contained in Article 192. This is complemented by Article 193 that requires states to protect and preserve the marine environment when exploiting their natural resources. Answering this question requires a reference to the South China Sea arbitration, which elaborated the scope of Article 192, and I quote, "The Tribunal considers it well established that Article 192 does impose a duty on states, that content of which is informed by other provisions of Part 12 and other applicable rules of international law. This general obligation extends both to protection of the marine environment from future damage and preservation in the sense of maintaining or improving its present condition. Article 192 thus entails the positive obligation to take active measures to protect and preserve the marine environment, and by logical implication, entails the negative obligation not to degrade the marine environment. The Arbitral Tribunal also stated that the content of the general obligation in Article 192 is further detailed in the subsequent provisions of Part 12, including 194, as well as by reference to specific provisions set out in other international agreements, as envisaged in Article 237. It is my task now, Mr. President, to discuss the other UNCLOS provisions, the other applicable rules of international law, and other international agreements that inform the content of Article 192 as they relate to climate change impacts. Ambassador Ponce earlier discussed the no-harm rule as a customary norm and the obligation of due diligence as an imperative duty. These are rules of international law equally inform the content of Article 192, following again the South China Sea arbitration. It is the obligation of states to adopt appropriate rules and measures to preserve and protect the marine environment and to ensure compliance by entities under its control and jurisdiction. Let me now expound on the other provisions of UNCLOS and other rules of international law that are implicated in the obligations in UNCLOS to protect and preserve the marine environment from harmful effects of climate change, namely the duty to cooperate, duty of due regard and good faith, the requirement for environmental impact assessment, the precautionary principle, the rule on equity, and sustainable development. I will also incorporate discussions on the specific provisions of other international agreements relating to environmental protection that inform the content of Article 192. These are the Convention on Biological Diversity, the UNFCCC, the Paris Agreement, and the Agreement on Biological Diversity beyond national jurisdiction. The Philippines would like to make the argument that in the field of international environmental law, various international agreements on environmental protection build upon each other to create a normative synergy between past, present, and future agreements. It is not only in Article 237 that this normative energy is found, but also in various provisions, particularly in Part 12, which call for the application or enforcement of generally accepted or applicable international rules and standards established through competent international organizations or diplomatic conference for the prevention, reduction, and control of pollution of the marine environment, and can be found from Articles 207 to 222 and include Article 297C pertaining to the settlement of disputes. Mr. President, there exists an obligation to cooperate. Article 197 requires states to cooperate on a regional basis to formulate standards and practices for the protection and preservation of the marine environment. The Tribunal in Mox Plant considered the duty to cooperate as a fundamental principle in the preservation of pollution of the environment under Part 12 of the Convention and general international law. This is reiterated in the South China Sea arbitration. Following the Arbitral Tribunal's ruling, the Philippines emphasizes the duty under 197 to cooperate on a global or regional basis, directly or through competent international organizations, for the protection and the preservation of the marine environment in relation to climate change impacts. Mr. President, there are obligations to act in good faith and to not abuse rights. Article 300 of Part 16 bears significance that state parties shall fulfill in good faith the obligations assumed under the Convention and shall exercise the rights, jurisdiction, and freedoms recognized in this Convention in a manner which would not constitute an abuse of rights. Exercising rights in good faith is akin and relates to the obligation to give due regard set out in Article 56(2). These two obligations, good faith and non-abuse of rights, are moral guideposts within the Convention that must also inform the content of the state parties' obligations under Article 192. Fulfilling all the obligations that we are discussing requires good faith and due regard to the rights of other states. Mr. President, related to good faith and due regard is the precautionary principle. Principle 15 of the Rio Declaration states that in order to protect the environment, the precautionary approach shall be widely applied by states according to their capabilities. Where there are threats or serious irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing, cost-effective measures to prevent environmental degradation. Similar language was incorporated in Article 3 of the UNFCCC. In the area advisory opinion, the Tribunal Seabed Dispute Chamber pointed out that the precautionary approach is also an integral part of the general obligation of due diligence, which requires states to take all appropriate measures to prevent damage that might result from the activities in the area, and this obligation applies in situations where scientific evidence concerning the scope and potential negative impact of the activity in question is insufficient, but where there are plausible indications of potential risks. The Chamber also observed that the precautionary approach has been incorporated into a growing number of international treaties and other instruments, many of which reflect the formulation of Principle 15 of the Rio Declaration, and that this has initiated a trend towards making this approach part of customary international law, as clearly enforced by the inclusion of the precautionary approach in the nodules and sulfides exploration regulations. The latest in this trend, Mr. President, is the BBNJ agreement, which provides in Article 7 that in order to achieve these objectives, parties shall be guided by, among others, the precautionary principle or the precautionary approach as appropriate. Another general obligation under UNCLOS and customary international law is to conduct environmental impact assessments, or EIAs. Article 206 in relation to 205 provides the obligation to conduct EIAs for activities to be undertaken in the marine environment. In the area advisory opinion of the Seabed Disputes Chamber, it was stressed that this is a direct obligation under the convention, and a general obligation under customary international law. Citing pulp mills on the River Uruguay, the Chamber said that this is a requirement under general international law, where there is risk that the proposed industrial activity may have a significant impact in a transboundary context, in particular on a shared resource, and considered that the obligation also applies to activities with an impact on the environment in the area beyond the limits of national jurisdiction. Related to Articles 205 and 206 is Article 204, which imposes the obligation to monitor the risks or effects of any activities which they permit or which they engage in order to determine whether these activities are likely to pollute
the marine environment. The South China Sea arbitration emphasized that in order to fulfill the obligations under Article 206, the state must not only prepare an EIA, but must also communicate it by terms of 205 to competent international organizations, which should in turn make them available to all states. The obligation, therefore, is twofold. Of more recent significance is the BBNJ agreement, which has a dedicated part from Articles 27 to 39 on EIAs, which elaborates on this twofold obligation. Once it enters into force, the BBJ agreement could become a benchmark in elaborating these obligations. Mr. President, there exists an obligation to observe the norm of equity. Central to UNCLOS's contribution to the strengthening of peace, security, cooperation, and friendly relations is the principle of justice. And from justice proceeds equity. In the Continental Shelf case, the ICJ said equity as a legal concept is a direct emanation of the idea of justice. Equity has had a long tradition and has been robustly applied by the ICJ and the Tribunal in maritime delimitations, most recently in Mauritius versus Maldives. Equity's application should not be limited to maritime delimitation, but should also apply with fervor to these advisory proceedings. To borrow the language of the ICJ in the North Sea Continental Shelf cases, whatever legal reasoning the Tribunal adopts, its decision must be, by definition, be just, and therefore, in that sense, equitable. The International Panel on Climate Change has stated that equity remains a central element in the UN climate change regime. It is on the basis of equity in the context of climate change that the obligations under UNCLOS should be subject to the common but differentiated responsibility principle. Countries that have contributed to and benefited more from environmental pollution should carry a greater share of this burden, a norm enshrined in Article 3, Paragraph 1 of the UNFCCC and Article 2, Paragraph 2
of the Paris Agreement, as well in its Article 4, Paragraph 4. Mr. President, there exists an obligation to promote sustainable development. UNCLOS aims to promote the economic and social advancement of all peoples in the world. Pursuing economic development is crucially linked to the preservation and protection of the marine environment. We cannot, as in the past, interfere with nature without considering its effects on the environment. We need to carefully balance these two ends. As the ICJ pronounced in its judgment in the Gabchikova-Nagimaras project, this need to reconcile economic development with protection of the environment is aptly expressed in the context of sustainable development. The obligation under Article 192 is inextricably linked to the notion of sustainable development. In the context of climate change, the obligation to reduce greenhouse gas emissions is a cognate imperative in the pursuit of economic progress. And in this context, we are reminded of Article 4 of the Paris Agreement that states should undertake rapid reductions in accordance with best available science so as to achieve a balance between anthropogenic emissions by sources and removals by sinks of greenhouse gases in the second half of this century, on the basis of equity and in the context of sustainable development and efforts to eradicate poverty. To this end, the dictates of sustainable development should also inform the content of Article 192 in the context of all our efforts to address climate change. Mr. President, in closing, I would like to make several brief points. UNCLOS has been called the most significant achievement in international law in the 20th century and hailed as the Constitution of the Oceans. It ended confusion and chaos and brought stability, certainty, and legal certainty to our seas and oceans. As a living constitution of the oceans, it is the thread that weaves through international rules and standards, past, present, and future, relating to protection of the marine environment. Applying intertemporal rules in interpreting is allowed as long as it is consistent with the intention of the parties, reflected by reference to the object and purpose. And so, while climate change was not yet a prominent concern during the negotiations and adoption of UNCLOS in 1982, there is no other way to interpret this important document and its provisions without taking into account climate change and its effects on the marine environment. Treaty law icon Professor Ian Sinclair also believed that states can take an evolutionary reading like this under these circumstances. Through the codification and progressive development of the law of the sea, UNCLOS contributes to the strengthening of peace and security in accordance with the UN Charter. The warming of the planet and the resulting changes to the natural environment pose numerous threats to humanity. Increased competition for resources like fertile land and fresh water are already disrupting societies and uprooting entire communities, exacerbating current conflicts and fueling new ones. There are alarming estimates of the potential scope of forced migration due to climate change. The global climate crisis is, therefore, a key risk to international peace and security. Climate change can unravel the architecture of UNCLOS itself and undermine the world order it has helped to create over the past 4 decades. The Security Council is responsible for the maintenance of international peace and security. However, the Charter does not define what exactly constitutes a threat, and the Council is tasked with determining its existence. Today, 8 of the countries that are hosting U.S. peacekeeping or special political missions are among the 15 most vulnerable states to climate change. As early as 1992, the President of the Security Council, speaking on behalf of its members, said, "The absence of war and military conflicts among states does not in itself ensure international peace and security. The non-military sources of instability in the economic, social, humanitarian, and ecological fields have become threats to peace and security." At the meeting of the Security Council June this year, the vast majority of speakers recognized that the climate change crisis is a threat to global peace and security, and that it must ramp up its efforts to lessen the risk of conflicts emanating from rising sea levels, droughts, floods, and other climate-related events. The rising levels of the oceans will inundate islands of low-lying coastal states, which could potentially shift maritime boundaries. the potential loss of maritime boundaries as a result of sea level rise will inevitably lead to conflicts in fisheries and other marine resources, but more importantly, could impact the stability of boundaries and trigger conflict. The Philippines understands and respects the concerns of the Arbitral Tribunal in Bangladesh versus India that settled maritime boundaries would be jeopardized if we introduce climate changes, if it be allowed to influence the delimitation process. The Philippines believes that international courts and tribunals and the world itself would not necessarily have to face this dilemma if we are able to stay a step ahead of climate change. Mr. President, staying a step ahead of climate change is the existential challenge for us all, as emphasized by President Marcos of the UN General Assembly last year when he said, "There is no other problem so global in nature that requires a unified effort." The decision of the tribunal as a consequence of these proceedings could and should be a crucial and pivotal part of these efforts. Mr. President, based on the arguments and proof presented, the Philippines respectfully submits. First, the tribunal has jurisdiction to give an advisory opinion in response to the request submitted by causes. Second, there exists no compelling reason for the tribunal to decline giving an advisory opinion. Rather, what exists are compelling reasons for the tribunal to exercise its discretion and issue an advisory opinion. Third, the advisory opinion should rule that there are specific identifiable obligations on the part of state parties to UNCLOS, including Part 11. A, to prevent, reduce, and control pollution of the marine environment in relation to the deleterious effects that result or are likely to result from climate change, including through ocean warming and sea level rise, and as ocean acidification, which are caused by anthropogenic greenhouse gas emissions into the atmosphere, and B, to protect and preserve the marine environment in relation to climate change impacts, including ocean warming and sea level rise and ocean acidification. And fourth, there exist norms in conventional, customary, and general principles of international law that support and reinforce these legal obligations. Mr. President, members of the tribunal, thank you.
Thank you, Mr. Sureta.
Enjoyed this video? Hit the like button and share with your friends. Also, subscribe to our channel for more videos like this. Thanks for watching.